Benjamin Franklin once said, "Nothing is as certain as death and taxes." He left one thing out, and that is birth after a heartbeat. Now, you can forgive him because, though he was a scientist, he didn't know the data that we now know about that. Since 1992, when Casey was decided, enormous studies have now shown that there is a virtual 95 to 98% chance of a child being born once the heartbeat begins within its embryo. That is a prediction that means that each one of us who have been born began our lives being born when our hearts began beating. And the question is, should we deny those children whose hearts have been begun beating the right to become full human beings the way we have? Now, what about the Supreme Court? Is the Supreme Court immune from scientific evidence? The answer is no. Has it ever changed its mind because of new scientific evidence? The answer is yes. Take, for example, back in 1905. The court decided the case of Lochner versus New York, which held that there was a right of contract and that New York could not protect the health of bakers because it upset the right of contracts and that bakers were not a class that deserved some kind of protection. A few years later, a brilliant lawyer named Brandeis convinced the court that women needed special protection, and he brought all kinds of scientific evidence to change the court's mind, and the court did in Muller versus Oregon. Even in Roe and in Casey, you see the court changing its mind. The opinion in Roe is so lacking in any scientific basis that you could almost see the embarrassment of the plurality in Casey attempting to make it right. But where in Roe it said that abortion was to be a fundamental right that could only be compromised by a strict scrutiny test, in Casey it said an undue burden test. Where in Roe there was a tripartite three-semester system, in Casey there was a two system with viability or not viability. Where in Roe it said that the state had an interest after viability in the fetus's eventual birth subject to DOE, which meant no real protection whatsoever. In Casey, the court said the state had an interest in the life of the fetus from the time of birth. Now, the big line between that the court had put into place in Casey is, as we said, viability. And it's a strange line. First of all, most doctors don't talk about viability in the way the court does. The court talks about viability as a fetus, which is, quote, likely to have a meaningful life of its own. Well, everybody can't have a meaningful life on their own unless they're related to somebody else in their relationships. The court also said that viability is when the fetus can survive on its own. But nobody can survive on its own. Everybody needs extrinsic help. What do doctors, obstetricians say about viability? They say a viable fetus, a viable pregnancy, is one where the heart is beating and it is likely, almost inevitably, to reach full term. That's what doctors say viability is, not what judges say viability is. Now, why did the court say viability struck at that time when the child could survive on its own? What does that have to do with it when it still needs help? Why does the court say in Casey that the woman has to carry the child to term when it can survive on its own? The reason why, when you deconstruct its reasoning, it requires that the woman carry the child to term is that that's the best protection of the child to reach full term. States that had tried to pass laws which would have allowed abortion, but with procedures that would have saved the child, the court struck down. No, the woman must carry it till term. Well, we have a much better marker now. The marker is heartbeat. That marker was not available to the court during Casey. We didn't see the statistics. We didn't see the reality of it. And so if we have a law now that says that in order for the state to prefer childbirth, which the court says it can, remember, It didn't say prefer the life of the fetus over the woman. It said prefer childbirth over abortion. There is no better marker than heartbeat, and that's what this bill will protect.